Welcome to Self-Represented in Family Court. Your host, Tracey Bee. That's me. So, here we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass. Well, hello there, and welcome back. You're listening to Self-Represented in Family Court. And I'm your host, Tracey Bee, Family Court Strategist. So today I wanted to talk a lot about parenting plans. Yay, that's super fun, I know. And there's so much to know about parenting plans. The first thing I want you to know is that they are not at all what most parents think they are. And depending on who creates your parenting plan, whether it be you as pro se, a mediator, a parent coordinator, a co-parenting therapist, your attorney, depending on who creates your parenting plan, there's always going to be something that's overlooked or missing or underestimated or overestimated. I mean, there is no one size fits all with parenting plans. There just isn't. And a lot of professionals, a lot of family law professionals will have you think that there is. I mean, there's even custody exchange website, I think it is, and that is I think that's the only reputable website source that people go to for customized parenting plans. And I don't think there's anything wrong with it. I just think that parenting plans should accompany an actual discussion. A discussion should accompany parenting plans, discussions with the parents, preferably a neutral third party, but definitely an attorney who is well versed with dealing with your judge or the specific judges in your jurisdiction or the jurisdictions that might apply, if at all possible. Because the reality is a parenting plan that's created without the court's input or intervention, should I say, is basically a toss-up. It really is a toss-up. And unless you're going to create a parenting plan and you both are going to abide by it, then chances are you're going to go before a judge for some reason or another with respect to your parenting plan. I can assure you that. I don't have any numbers. I wish I could find a source that could give me some legit data and statistics. But in my experience alone, and not just me, when I was practicing or when I was a guardian ad litem, but just talking to other attorneys, talking to mediators, talking to guardian ad litems, talking to litigants, there's just no one way to avoid, getting a judge to, intervene with a parenting plan. Again, unless you guys are low conflict and, chances are you don't need any court intervention. And you may not even need a parenting plan in that respect. But, for whatever reason, some people choose to have one. And they're not a bad idea to have. They're not. Especially in situations where, some people, they live by, seeing things in black and white, having some sort of structure. And a parenting plan serves that purpose. But a lot of times it has a lot of people have way more optimistic views of what a parenting plan will do. Especially in high conflict situations. I mean, it's like, I don't know, it's like going down a rabbit hole. That's my favorite term now, going down a rabbit hole. But anyway, so that's what I'm talking about today. And there's several reasons why I'm talking about it today, because I recently did a mastermind or a discussion group with peers who were talking about parenting plan. And one of them had asked about basically a clause in the parenting plan that, um, gave the parties the directive to seek mediation when there was an issue with respect to a provision of their parenting plan. And, I just thought that was interesting. I thought that was interesting because, oh, yeah, judges want to see you do that. But then there's a whole set of issues that actually sparks when you include provisions like that. So that just, that and a lot of other things had actually served as the impetus for me to do this week's show. So if this is your first time listening, my podcast is really informational. It's not to give any legal advice, anything like that. So I want to put that out there. It's really focused on helping self-represented understand the intricacies of family court so that they can actually navigate their way through it with much more ease and success as opposed to someone who's represented. But, lawyer represented, I have lawyer represented clients and listeners too because they benefit from the information or the perspective that I share. For those of you who are new, again, I am a former family law attorney, mediator, parent coordinator, podcaster, blogger, author, and single mom of a young boy of 12 years old. But I am most proud of my role right now as a family court strategist. And because that role as a family court strategist, I get to pick apart every single aspect of the family law experience, specifically as it relates to your case or your issues as a self-represented litigant. So, parenting plans, first of all, are an agreement. They're usually an agreement between the parents to, as to how they're going to parent their child or children. And it's usually something done in writing, and it's usually binding. Who does it? As I mentioned a few minutes ago, it can be the litigants themselves, mediators, lawyers, guardian ad litem, parent coordinators, CCRCs, wherever you are, it depends. Parenting plans are, in some states, are required. Once you file for divorce and there's children involved and custody is an issue, or you file for custody, or you file for modification of custody. Some states, like I think Florida is one of them, and I believe Tennessee might be one of them, where you are required to file a parenting plan with your petition or your motion. I believe somewhere in the Midwest they do that too. I forget which state it is, but there's a few states out there that's it's a requirement. Whether you file it with the actual petition or you file it almost instantly after that. There's a few states that require that you submit a proposed parenting plan. It's a proposed parenting plan because it's not binding on the other party because it's not agreed to, or it hasn't been so ordered by the court. So it's a proposed parenting plan until it's adopted, until it's accepted and so ordered. There's quite a few states, and I didn't get a chance to count the number of states, but there's quite a few states who actually have their own version of a parenting plan on their website, on their court's website, whether it's broken down by county or by state. If it's by county, then I'm sure you can use, if you're in one county that doesn't have it on their site, you can go to another county in your state and use theirs and just change the county information on top. And in some respects, you can do that cross states as well. Again, I don't believe in using one-size-fits-all parenting plans because from the court's perspective, yes, it's easy. That's one thing out of their, off their list, off their desk, off the judge's desk that they don't have to deal with. But when you are one of the parents and you have to live with a co-parent who has to abide by this agreement, it can create a whole other set of issues that the judge has no interest in dealing with. So for you, especially if you're self-represented, I am not a fan of you doing parenting plans without some professional assistance in that, whether it be someone to help you create the parenting plan or someone who could who could take a look at it once it's done before you actually submit it to the court. Once you both agree, and then you have someone look at it, you can have a respective professionals for each of you to look at it, or one that you both agree on to look at it. But I am just not a fan of pro se that gets submitted in parenting. But again, unless you're extremely low conflict and neither one of you foresee any issues with it. I've met people who've had parenting plans in place for 10 years and it went well, but that's very few. Um, because as I mentioned, from my experience, there's always going to be some sort of issues that come along down the road with respect to enforcing the provisions of a parenting plan. So, parenting plan page lengths. That gets interesting because I'm talking to mediators, or I was taking my co-parenting mediation training, and who was actually hosted by a therapist. And she said when she does parenting plans, they're usually 30 pages long. That is ridiculous to me. That is ridiculous. But I do notice that parenting plans created by mediators or any mental health professional who has an expertise in parenting or in child development or anything related to that, they will actually draft a 30-page parenting plan. And when clients come to me and they show me their parenting plan and it's 30 pages long, I automatically assume it was a licensed or unlicensed. It was a mental health professional that created it, whether it be, again, a mediator, a co-parenting therapist, or whoever. Because lawyers don't typically create 30-page. I've never met a lawyer who created a 30-page parenting plan, unless they just basically adopted it from somebody else, from a mental health professional. Lawyers just don't create 30-page parenting plans. And right, wrong, or indifferent, I just think it's ridiculous. Unless the parties are going to do everything within their power to stay out of court. So that means if one breaks, provisions or ignore provisions or constantly violates provisions, and the other party, I don't know, tolerates it, or they find another way to get around it, or they work through it or whatever, then okay. But a 30-page parenting plan and a high conflict, and some people actually believe that the high conflict cases are the ones that should have the 30-page parenting plans. And I totally disagree. Because, again, there's no one size fits all. I just know from my experience, the more that's in the parenting plan, the more the non-compliant or the toxic other parent finds a reason to complain or to violate or to not adhere or be uncooperative. And I just think it creates a whole other set of issues that are unnecessary. That's just my opinion, and I'm entitled to it. I'm a strategist, so for me, everything is not just about resolving an issue now. Everything for me is about positioning yourself so that in the long run, you will minimize problems and issues. You're never going to get rid of all your issues as you're co-parenting, especially with a high conflict other parent. It's never going to happen unless they just, some life experience or life altering event happens that causes them to, not have the wherewithal to be so high conflict. I don't think they just go away, or until the kids, reaches the age of majority. But for me, as a strategist, to have a 30-page parenting plan for a high conflict family just says to me, you know what, they're going to be back in court. And I'm always thinking about the judge's perspective, because as a family court strategist, that is my view. That is my angle. It's the how you position your case, so that in family court, you're not necessarily the one who's going to be slammered from, whatever that is. So you have a 30-page parenting plan, and the other party is the one who habitually violates provisions of the parenting plan. And you want to file contempt every single time they do that. And someone may advise you that, yeah, you should file contempt every single time they do that. Well, if you listen to my last week's episode, you'll understand that is not necessarily the best avenue, the best move to make when there's habitual or constant or perpetual violations of a parenting plan. But why even put yourself in that predicament? Because If you're not going to file contempt all the time, then what do? What are your options? There are other options. And for me, the option is being preemptive. And for me, being preemptive means that you anticipate every action that they're going to take, or every roadblock or obstacle, or every objection, every antic they're going to pull, and you incorporate that into what your next move is going to be. And so for me, that means starting with a parenting plan that's not 30 pages long. I hope that makes sense, because sometimes my brain actually is way ahead of what I'm actually saying. But nevertheless, that's what happens. So, does a 2-page parenting plan work better? Not necessarily. No, not necessarily. Again, it depends on you. It depends on the other party. It depends on your kids. It depends on your personal predicament, your circumstances and situation. And the same for the other parent. It depends on your resources. It depends on your judge. It depends on your court. All of those things should be factored into you creating. That's exactly why I'm not a fan of the one size fits all, the templates, people just copy and pasting. I'm just not a fan of those, especially if you're in high conflict situations. I'm not a fan of those. So yeah, you need to take some time and create a parenting plan based on all those variables. Ideally, if you can, as many as you can anyway, because there's no guarantee. No one can give you a guarantee in family court. That's the bottom line. But we can definitely minimize. We can surely minimize the level of conflict or the level of litigation, that the extent of the litigation that you may expose yourself or make yourself vulnerable to. And so whether it be 2 pages, 5 pages, or 10 pages, you should certainly think about all the things and do it together. Do it together or do it on your own. Do it on your own. Get as much information from the other party. Sit back and reflect on the things that's happened in the past, or the things that you know them to be. And create a parenting plan, a proposed parenting plan based on that, and then send it to the other party, and let them do the same thing, or send a counter proposal, and you go from there. But I really think it takes time. It takes time, and it should take effort to do, to create that. You definitely should not be going on social media or up to strangers and say, "Hey, let me have your parenting plan because I need it. Let me have a copy of your parenting plan because I need it for my own case, and I just want to change the name and the court information on it to use in my case." No, that's not the best idea. Trust me. So, what should be in a parenting plan? There's some specific provisions that you should certainly include in your parenting plan. And there's so many sources on the internet as to what should be included. But I always tell people to start with their court's website to see what information is on there. If they don't have an actual template, they may have the requirements, if there are any in your state, in your jurisdiction, as to what should be included in a parenting plan. But a parenting plan typically covers the custody arrangement, whether it be joint legal, joint physical, 50-50, shared custody, sole legal, sole physical. It should have the actual visitation schedule or access schedule or parenting time schedule. The more specific it is, the better. Again, with respect to particular schedules, most jurisdictions have like a customary, I don't want to say standard, but a customary schedule that they follow. For instance, in New York City, it's typical for the non-custodial parent to get every other weekend and one evening during the week. And then there's some states like New Jersey where if the parents were married, they typically would get, whatever they agreed to, 1 week on, 1 week off, 2-3-3, 2-5-5-2, or whatever it is. But it's usually a 50% time unless there's some specific issues that the judge thinks doesn't warrant that. It usually includes summer time schedules and vacation time. It usually includes the pickup and drop off information, the time, the location, who should be accompanying the parent picking up the child, the holiday schedule, extracurricular activities, communication when the child is with the other parent, The communication meaning whether they can, have phone calls every night, video chats, whether they have access to texting. Um, it should include behaviors, whether parents should have, significant others um, at the, in the home when the child is visiting or having time with the parent, whether the either parent should introduce the child to a new partner within a certain amount of time, right of first refusal, safety issues, financial responsibility, blah, 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 traveling, who has the passport, address and other background information updates, relocation provisions. So the more you know these issues might be an issue for you and your child, your family, your significant other, and the other parent, the more you should actually address them. And again, there is language on anywhere on the internet that would help you decide or use as a baseline to come up with the actual language to include. Start with your court's website first. And then if there's nothing there, then you can just go to, any source that you can find on the internet. Just put in parenting plan provisions and add your state so that you can see what it looks like, what if there's any requirements or any specific language that the courts in your area are prone to use. I wanted to talk about a few provisions of a parenting plan that have created so much controversy amongst litigants. And lawyers too, I guess, but definitely litigants. The first one is the morality clause, and that is when, excuse me one second, I have to wet my throat. That is when the parties agree that they are not to introduce the child or the children to a new partner, a new mate, within or before a specified period of time. It's typically 6 months. Some people choose 3 months, but it's typically 6 months. They have to have been dating for 6 months before introduction should be made. There's no one who's going to enforce that. You cannot. So, for instance, your other parent decides they met a new girl, they met a new man. It's been, 4 weeks, and they want to introduce little Michael. And little Michael comes home, and they do introduce little Michael. And little Michael comes home to tell you, oh yeah, by the way, I met Sarah, or I met James. And who is that, Michael? Well, it's daddy or it's mommy's new friend. And guess what? They spent the night too. And so now you're livid because you refer to your parenting plan, of course, and there is this clause that both of you agreed to because both your signatures are on it that said that you are not to introduce new partners, new mates, new significant others to the child before they've been dating for 6 months. Well, how do you know they haven't been dating for 6 months? Well, because daddy or mommy told little Michael that they met at the Spring Fest. And the Spring Fest was just 4 weeks ago. So what do? Well, of course you get annoyed, you get angry. Of course, that's unavoidable. But what else can you do? What recourse do you have? Well, that's where it gets really tricky because parenting plans do not have legs and arms. They don't self-execute. They don't enforce themselves. That means that it's just a piece of paper. It's just a piece of paper. Even though it says, and even though you both agreed to it, you both signed this binding agreement, promising that you won't do this, somebody can unilaterally change their minds at any time. They didn't mean to. They meant it when they signed it. But this one is a special one, and it's time that they meet, my child because they're going to be around. Well, there's no guarantees they're going to be around, but what do? Well, not much you can do. Nope, not much you can do. Unless you have a clause in your parenting plan that issues that are come up as a result of your parenting plan should be addressed before a parent coordinator, a mediator, a co-parenting therapist, and you have that option. You can include a provision in your parenting plan to that effect, to that degree. But if there's nothing in there to, even if there is, and the other party chooses they don't want to go to mediation because there's no harm with little Michael meeting their significant other before the 6 month time, because they are sure that this person is going to be around. Because that's why you both agreed to this in the first place. You don't want to expose little Michael to a revolving door of new significant others, right? Well, guess what? No one's going to enforce that. No judge is going to enforce that because they can't. It's just some things you just can't enforce. What is the judge supposed to do? You know, that's an issue of values and morals that you guys decided on. It's not across the board. Some people don't have an issue with their kids meeting a revolving door of lovers or intimate partners. And who are we to judge, right? I mean, what damage does it do? We don't know. I don't know. I'm not a mental health expert who does research and collects data and do studies. So, I mean, theoretically, it may cause some sort of issues with them mentally and emotionally, but we can't avoid life. We can't shield the kids from every little thing we think is an immoral act or is against our values and beliefs. We just can't. Nor should we. Nor should we. And so that's the position of the judge. Just because the judge doesn't want to micromanage your co-parenting. They're not going to stand in a place of being God, because that's what you're asking them to do. And it's not going to happen. Because even if you decided to take the other party to court for violating that provision, the judge is going to issue a warning. Okay, don't do that again. Maybe. And that might be the most. If that's your sole reason for going back to court, the judge is going to, well, you agreed to this, so you should probably follow the agreement that you signed, and you swore that you would actually uphold. What more can they do? And I see this often. I see this so often. And it's typically mom. It's typically mom who has an issue. And I get it, I'm a mom. But I don't think I would really worry my pretty little head over my son's dad. He passed away, he's no longer with us. But I don't think I would worry my pretty little head about my son's dad, exposing my child to different women, because I parent my child, you know, based on what he's exposed to or what he learns or what environment he's in anyway. And that includes what he did with that. So I'm not trying to control another adult. I'm not naive enough to think that I could do that. If they're gonna do what they're gonna do anyway. And no one's gonna stop them. If they don't have enough morals or values to agree with you, or they don't have the same morals and values as you do to agree with you and to not expose your child to a revolving door, then they have to deal with that. They have to live with that. It's your job to focus on parenting your child and instilling those morals and values in your child regardless. That's the only thing you can do, because I wouldn't waste my time going to court over that. Another provision is the right of first refusal. The right of first refusal provision is almost akin to the morality clauses in parenting plans. Right of first refusal is, it'll say something like, in the event that the other parent is unavailable or an emergency comes up, he is to or she is to notify me, and see if I'm available to take my child when the child is in their custody or having access time or visitation time with the other parent. That parent is to reach out to me to see if I'm available before they seek a babysitter or a nanny or family member or a significant other to watch or take care of our child. So they have to give you the opportunity first to refuse taking over, the parenting time that they were supposed to exercise. And a lot of times they just don't do that. They just don't do that. They don't have the, they for whatever reason, whether it be they just don't want to, the logistics, whatever it is. Again, who's going to enforce that? Now, there's some instances where those provisions are added for a reason. It could be because, there's been safety concerns or safety issues in the past, and the options that that parent has of care providers or caregivers or nannies or babysitters or whatever. The options are known and have been identified to be unsafe options for the child. That's different. That's very different. But just, you know, on a general level, on a general basis, you just want to be that parent to be called first just because you are a mom or you are a dad. Again, that's no one's going to enforce that. How can you enforce that? How can you? Again, the judge is not going to really get involved, and if they do, they're going to, maybe issue a warning, but that doesn't stop anybody from doing it again, over and over again. It really doesn't. So, for those reasons, those two provisions, me myself, I would never actually waste time. And people say, I'll just include it anyway, but why? Because what it does is it gives somebody a false belief that they can run to court every time that it's violated. And you don't want to run to court every time there's a violation of a parenting plan. You just don't. Please listen to my contempt episode that I did last week so that you understand why. You just don't want to run to court every single time a parenting plan is violated. I mean, there's some specific provisions of a parenting plan that make it maybe more advisable to actually go to court. But even in those instances, you still want to position your contempt slash modification slash enforcements around who your judge is, what your judge's preferences are, and all of those things. You still want to do that. Again, listen to the contempt episode so you'll get an understanding. But just because dad or mom continues to ignore the right of first refusal clause or the morality clause, no, I wouldn't necessarily run to court for those. I may use them if we go to trial, if we were to ever go to trial, or we would ever have another reason to seek modification or anything, or relocation or anything like that. I may use that information then, but I'm just basically stacking it. I'm not actually making that the central focus of my application or petition or motion to the court. I may add those things in when there's other more important issues that I'm actually going to court for, if that makes sense. So, and even then, I still wouldn't necessarily bring up those two clauses as my basis for, asking for consent. Maybe for modification, if I can fit those into the best interest of the child. But those two clauses have really little to do with what's in your child's best interest based on your state's factors. If you don't believe me, go and get a copy of your state's best interest of the child factors and tell me where in there does the morality clause fit in or the right of first refusal clause fit in. Please tell me. If you find it, feel free to email me, Tracy@thedivorcesolutionist.com. And if you can convince me of that, I will give you a free half-hour strategy session. I promise. If you can convince me that those two provisions actually fly in the face of the best interest of the child factors, you can find those factors on justia.com, www.justia.com, for your state. Get those factors, read them thoroughly, understand them, and then if you can convince me after you've done that, feel free to email me at tracy@thedivorcesolutionist.com, and I will, and if I'm convinced, if you've succeeded, I will schedule a free 1/2 hour strategy session with you. Absolutely. I will do that because I'm not convinced at all. And there's some other provisions that have nothing to do with the best interest of the child factors, but in the grand scheme of things, when the best interest of the child factors are not explicit, at least to you anyway, especially if you're pro se or self-represented, they're easier to tie into the factors or the general principles of your court, in lieu of the best interest. The best interest factors are based on the emotional, physical, developmental, intellectual well-being of your child. So and not what you think, it's what the court thinks. So some courts will take the spiritual well-being of the child as, a factor, or as they will use that to as a basis for making a determination. Like Pennsylvania, I think, does that. Um, but if you look at your factors and you don't see exactly where they fit in, those provisions fit in, not those provisions that I mentioned, the other provisions fit in, they may fit into the overall principles or the underlying principles by which your court basis is well being criteria on. So I hope that makes sense as well. I know I could speak in a way that's kind of confusing. I try to make things as understandable as possible because I do understand that, especially when you're self represented, legalese or legal terms or legal phrases or even just legal conversations can be, really overwhelming and confusing. So feel free to email me though if you want more clarification on exactly what I talked about today. So if you have a parenting plan and it's 5 years old and your child is not, or your children are not at the age of majority, revisit it. Typically, when they reach a different developmental stage, it should be revisited. So if they're not in the newborn to three stage, or the 3 to 5, or the 5 to 9, or the 9 to 12, or the 12 to 15, like when they go from one of those age gap groups to another, you should probably revisit it. If your parenting plan didn't cover all of those, and it's unlikely that it did, because it's hard to anticipate what your 1-year-old is going to need at 12 or 13. We can hypothesize, but we're not going to know exactly because things happen. So it's really, really ideal for you to revisit the provisions of your parenting plan when your child is, especially between, if you've had it done at 1 and they're now 8 or 9, it's time. It's time to revisit that and maybe modify it. And you can do that on your own. You can modify your parenting plan upon agreement with the two parties with no outside intervention at all. Again, if you're going to do that, though, at least have someone who's well versed in parenting plans look it over to be sure that you're not creating more outlets or more avenues or more conduits to go right to court. Um, the court's perspective on parenting plans, the court doesn't want to really be involved in creating parenting plans. They really don't want to get involved with, specific provisions of parenting plan. Judges just don't, that's just not their thing. That's why some courts require you to go to mediation, because they're hoping that you'll get a parenting plan for mediation. And even the ones that require you to submit a parenting plan with your petition or whatever, it's usually a form. It's usually the ones that do that, they usually have a form for you to use, a template for you to use for the parenting plan. And that's because that's how much judges just are not going to get involved with the nuts and bolts of your parenting plan. That's just not their thing. That's just not. They want to litigate cases, and they really want to do that. But they want to, address the bigger issues, and, the detail of your agreement or your parenting plan is just not one of them. I mean, with respect to the other things, the things like custody, yeah, the custody and sometimes the visitation, but more than that, and relocation. But a lot of times more than that, no. They'd rather you deal with that with whomever you're going to use to help you iron out those details. So, I do parenting plans. I am trained as a parent coordinator and as a co-parenting mediator. And so I do parenting plans for people like you. So if you need a parenting plan done, or you have one and you want someone to look at it to ensure that you've covered the things that you think are going to be an issue for your specific circumstance, not anybody else's, yours, then feel free to reach out to me at tracy@thedivorcesolutionist.com, and I will help you out. I can help you out. If you need more help with coming up with negotiating your parenting plan, or talking about how your parenting plan is going to play in your overall divorce or custody dispute, or how your judge is going to view your parenting plan and anything else that you might have that's a nuanced issue with respect to your custody dilemma, then you can definitely take advantage of a full 1 hour strategy session or a full 1 month strategy consultation package where we work together for 1 straight month on anything actually in your case. But I really believe that you should not take 15 minutes or 30 minutes to come up with a plan and just submit it, because that is not wise. I do think when parenting plans are created by mediators or anyone, especially mental health professionals, that there should be someone with a legal knowledge background to have a look at it and give their input, especially if it's someone, a legal professional within the same jurisdiction who knows the judges in your court. I really think that's the smart move to do, because they're going to look at it from a different perspective, and they're going to see things from most should be able to see things from the court's perspective, like things like I mentioned a minute ago with the morality clause and a right of first refusal. There may be other things in there that the family law professional could actually shed some insight on that you are not aware of, or the mental health professional is not aware of. And a lot of mental health professionals who are not involved in court at all, it's hard for them to conceive where a judge would have an issue with when it comes to certain provisions in a parenting plan. And I respect what they do, and I really do, and I appreciate that their focus is usually on improving the co-parenting relationship overall, because I think that is extremely, extremely important. But I also think that they should work together. They should work they should work together, because even though the mental health professionals' intention is to improve co-parenting and teaching or enlightening or advising or guiding or whatever it is, I do think, and even though that's their objective, and usually that's the party's desires, I do believe that sometimes those desires change at any moment, and so all that work could have been in vain. And so because of that, it's there's a possibility that anything could actually land the parties in court, and because of that, family law professionals should be involved. They don't have to be representing you. They just should, like I said, review or advise or consult or whatever it is, whatever capacity or role they can play. Anyway, that is all I have this week. Thank you so much for tuning in. I appreciate each and every one of you listening. And until next time, take care. I want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com.